because I didn't get that part right. I thought it was 5 years. I remember
Right.
that one.
We're going to start a video for Course 3 Residential, and we're discussing now Chapter 9. So the assignment of the agreement, this is where assignment refers to transfer the rights of a contract. So you can assign, say you bought a new builder home, for example, and you have the right to assign it, and builder or the buyer has to pay a fee. You can assign it to another buyer for a difference and make some profit.
Okay.
It says personal service contracts are not assignable, though.
Yeah. Okay.
So as a general rule of thumb, contracts are assignable except some exceptions, and those are personal service contracts are not assignable. So you have the right, if there's an assignment clause, it refers to the rights to transfer the rights of the contract. Okay? And people do that a lot when they go to new builder sites when they sell out.
Yeah.
And they get a couple extra ones for assignment, and then they got buyers waiting, and they say, all right, give me $5,000 extra, and I'll assign it to you.
All right. Essentially just selling a piece of paper.
Pretty much.
Yeah.
Essentially selling a piece of paper. But it's the exception is the personal service contracts, which you cannot assign.
Right.
So the liabilities versus rights in a contract, liabilities under contract can't be generally assigned. Your liabilities are not being assigned. However, the liability can be assigned with an express consent or implied intention of the party. So the rights to when you're looking at rights under a contract can be generally assigned. So I can give you the right to buy and control and rent and all those things. But if there's a liability condition in the contract that you're signing, so even though you're signing it, there could be a liability clause that says you're still liable if the guy you assigned it to doesn't close. So you have to check out the liability versus the rights in the contracts before you start doing assignments.
All right.
Because you don't want to get into trouble.
Right.
Assignment by the buyer is if a buyer wants the right, a clause must be inserted into the agreement because you have to have an assignment agreement. The agreement purchase. So the seller should carefully assess this option, as no recourse would be possible against the original buyer when you do an assignment by the buyer.
Okay.
So if the buyer has a right to do assignment in an agreement of purchase and sale, there might be no recourse unless you're specifying a different type of clause. Okay, so he's going to be free and clear after it's assigned.
Okay.
Assignment of lease is a tenant may assign or sublet, and that's with at will or without the approval of the landlord, unless the lease prohibits it in the Tenancies Act. Because by law, tenants are allowed to do a sublease unless you prohibit it. So unless you put a clause in there that says no, you are not allowed to do any subleasing, they're actually allowed to do subleasing. Okay? In a commercial lease agreement allows a tenant can transfer the leasehold interest to a new tenant. However, the tenant is not released by the landlord. If something happens, they're still liable to the landlord.
Okay.
In the commercial lease. So, but also it can apply to a residential lease too. Like if you do an assignment or you do a sublet. Like if you do a sublet, that's completely different because you're actually the original person is still liable. Okay. So the next portion says subletting. When the tenant transfers something less than the leasehold interest, it is subletting. So subletting will be done all part of the premises, and then it says it remains liable to the landlord. Okay. So both the tenant and the assignee or sublet tenant will sign a form agreeing to be bound to the main lease.
Okay.
So that's the issue with subletting.
Right.
Okay, so if you do an assignment of the lease, you can, if the clause says you're free and clear and there's no recourse, you're pretty much good to go. You don't have anything to worry about. There's no original liability on the original person. But if you sublet, you're going to have the liability in case they default.
Right. Okay. Yeah.
Okay. So obtaining insurance, you have to get homeowners insurance if you're living in a home. Like if you're a tenant, you need to get tenants insurance.
Okay.
You're supposed to get that. It's by law you're supposed to have it, because if you don't have it and something happens, you could be on the hook for the entire damage.
Okay.
And go to court for it. So it says that insurance companies, they scrutinize properties with certain things. If they have electrical wiring, old-fashioned wiring, or they have oil fuel tanks and things that are related to environmental issues or insurance claims, you might have higher insurance, or you might have the risk of not even getting insurance. So it all depends. Or they could also remove certain things and say that part won't be covered. So that's something that has to be looked at pretty carefully when you're getting insurance.
Okay.
Especially in old homes. Residential insurance coverage is there's property insurance, which covers you in the loss or damage of property, right?
Yeah.
Liability insurance covers you from accidents or incidents that are arising from a situation. Endorsements, there's additional coverage for valuable personal articles. So endorsements could be for your diamonds or your expensive Rolex or whatever the case is.
Yeah.
Policy conditions are usually procedures related to the claims and obviously the provincial laws, but also the policy conditions are related to whatever you agree to. So if they say you got a deductible of $1,000 or whatever the case is, then that's your policy condition too. Okay.
Okay.
Condominium insurance is required. That's for excluding the unit, any improvements made by the owner, and that's liability coverage is also required too. The unit owner needs to have this for general coverage, but it's not covered by the corporation though. So renters need to have content insurance, which covers all their personal belongings. The insurance that you pay for condo insurance covers the building and liability. So the unit owner usually wants to insure any improvements he's doing that could be at risk.
Right.
So let's say you're putting in expensive stainless steel appliances and a sub-zero fridge and you're spending $20,000, you might want to get separate insurance on the improvements.
Okay.
But for the original unit and the original structure, that's covered by condo insurance.
Okay.
But you still need to cover your other items that are not part of the condominium. Because they weren't there before. They're all added additions.
Yeah.
So the heritage properties under the Ontario Heritage Act. So these affect intended uses for the property, the impact, how you make external and internal changes. So a lot of the times they want the outside to remain the same.
Okay.
Even if you're changing a few things around the inside if they allow it. You have to do a disclosure clause that has to be inserted to the agreement if it's a heritage property. Okay. Also, Ontario Heritage Trust is an agency of the Ministry of Culture, so you can remember that part.
Yeah.
So the agency of Ministry of Culture, and then what they do is they establish the Municipal Heritage Committee. So Ministry of Culture promotes Ontario's heritage. The municipality will establish a Municipal Heritage Committee made up of 5 or more people. So 5 or more people are in there. So what that committee does, it just advises against the local matters of heritage items.
Okay.
Okay. So Conservation Review Board, that's for anything that they want to conserve, parks, things that make power, like Niagara Falls,
Yeah.
anything. They can conduct hearings and make recommendations regarding heritage matters. So this Conservation Review Board, they can hear objections to the heritage designations and make recommendations. The board does not have decision-making powers, though.
Okay.
It's just a review board, and they'll make recommendations. So they're like an advisory board.
Okay.
So all they do is just really give advice on what could happen or should happen.
All right.
But that doesn't mean that's going to happen. Okay?
Yeah.
So key statutory provisions are, salespeople need to be aware of these following. There's alterations, so property can't be altered to affect a heritage designation. That's
Okay.
for sure. You can't do things like that. So you can't tell a dentist, yeah, buy this old home and convert it into your clinic.
Okay.
But there's a lot of stuff that we don't even know that can be done or not. Written consent is alterations are only permitted if the owner gets approval from the council. So if he says, I want to make additions in the back and add these other buildings behind it and gets approval, fine, no problem. Demolition of a heritage property should be approved in writing, but usually that's pretty tough to get.
Yeah.
Okay. So we understand power of sale pretty well. It's our, when a property comes up from somebody defaulting. It's under the Mortgage Brokers, Lenders, Administrators Act. It's the power of sale is basically where someone is acting to enforce where the mortgage has been in default for a certain time period. In that time period, they haven't rectified or done anything. So it's inexpensive. It's the fairest way for the mortgage company to remedy the situation. It allows them to retrieve only what is they're entitled to. If there's a surplus, it's paid to the mortgagor.
Oh, really? Okay.
Yeah, in a power sale.
I didn't know that. Yeah, so like the house we bought was a power sale.
Right.
And so if they only own 100,000, we bought it for 192, then the bank would get the 100,000 what they're owed, and then the old owner who defaulted on the mortgage would get the 92.
Yep.
Oh, okay, I didn't know that. That's not too bad.
Yeah.
But the bank picks the price of the home.
But remember the bank has legal fees too, and their lawyers are expensive, and there's other fees that you're not looking at.
Yeah, okay.
And the process for hiring property manager, setting up keys or locksmiths, I don't know what they're doing. It all depends. They can charge you quite a bit for that stuff.
Okay.
Right? And they have their own administrative penalties too, remember.
Yeah, okay.
So they have a mortgage breaking penalty. They could charge you like 20, 30 grand on that, but whatever's left over, they'll pay it back.
Okay.
But they'll charge, like thoroughly.
Yeah.
Naturally. So the listing and selling process is a notice of sale. Must be provided to the mortgagor and encumbrances who have interest in the property. The notice is sent 15 days following default. In contract or power sale, 35 days are given to the mortgagor to remedy. So 45 days are provided in total. 45 days are provided, that's what I mean to say. So you have, you get a notice, it's sent in 15 days following the default. So you got to wait 15 days to send the notice.
Yeah.
And then the power of sale says 35 days are given to the mortgagor to remedy. So here you go, you got 35 days to pay up.
Yeah.
And then the statutory power of sale, 45 days are provided.
Okay.
In the power of sale. So no action can be taken by the mortgagee during the 35 to 45 day redemption period. When this time passes, the mortgagee can take possession to sell the property now.
Okay.
So now they can say we're gonna empty it out, change the locks, put your stuff in storage, whatever.
Yeah.
So the certificate of power of sale is OREA Form 262. It's required by a listing brokerage, mainly used to verify matters of the property under power of sale. So if you take a certificate of power of sale, OREA Form 262, it'll just be used to verify the power of sale, and also concerning clauses that might have to be added into the agreement if somebody wants to buy it.
Okay.
So selling under power of sale, OREA Form 106, used with along Form 100.
Okay.
The seller has the authority to sell the property. That's the mortgage company. A default in mortgage has occurred, and there's no guarantee of chattels or fixtures, so it's always sold as is.
Yeah, right, okay.
So marketing a power of sale, you can conduct 2 appraisals at least to establish the value. That's what the banks do. They'll call a realtor and they'll call usually 5 realtors, get valuations, or get 2 appraisals, and then pick one realtor at the end and put it up for sale. So you have to ensure reasonable time for marketing. The sale should not be too fast.
Okay.
But sometimes it can still be fast. So I don't know how they're actually saying that, but it can still be fast.
Yeah, ours listed, it was done right away.
Yeah, it can still be fast, depending. It's actually, they are usually fast, so I'm not really sure why they're saying it. But anyways, provide the widest possible marketing exposure. That's understood. That's common sense. You have to do that.
Yeah.
Make certain sale in the arm's length of the transaction, not relative to a business partner. So you're not selling the power of sale only to your friends.
Okay.
You're giving everyone an opportunity to buy it.
Right, yeah.
Road Access Act is implied and grants the right of way of necessity, so that is just something that they're mentioning. It says a tenement can't refuse the right of the dominant tenement.
Okay.
So if you have a lot here and a lot next to you, and you have a lake, and you need to cross his lot, have a road access to get to the lake, he can't refuse it.
Right, yeah. Okay.
The one who's giving you the authority or allowing the right of way, they can't refuse it if it's reasonable.
Okay.
Closing on access road, that means it's not been dedicated and accepted by the municipality.
Okay.
Okay. And it says that only closed by a judge's order or specific written instructions of all persons affected. So if there's a closure on an access road, it's only going to be closed on a judge's orders or specific written instruction.
Okay.
Okay. So for real estate practitioners, make sure there's an accurate description of right-of-way, for sure, and easements on the titles as required. You need to do that. That's very, very important to know them. You have to check them and make sure they're on there.
Okay.
And then we look at fences, it says that frequently there's disputes between neighbors for the boundary lines, but you can only check on an up-to-date survey.
Okay.
So if you don't have one, maybe you got to pay $1,500 and get a new one, if that's the dispute.
As far as like getting their neighbor to pay for half, that's just like a old wives' tale. They don't really have to do that, right?
They don't have to. They can if they agree to do it, but not. They don't have to be forced to.
Okay.
There's no obligation on their part.
Right.
So the line fences act as a property boundary, is what that is essentially. So
Okay.
that eliminates the disputes. Municipal fence bylaws, you still have to go through them to make sure that the height requirements and the temporary use of any fences that you're using are in compliance.
Okay.
The shore road allowance, that's initial shore road allowance, has 66 feet wide to the rivers and lakes.
Okay.
So you just have to remember that part. Encroachments are waterfront lots that may have boathouses, cottages constructed on the shore. Allowances constitute encroachment, and the survey is necessary for those cottages.
Okay.
Okay. So unique circumstances can include non-conforming use. That's kind of like also falls to those basement apartments that are not legal. That's non-conforming use. Or it could be that they are non-conforming today and they were legal before 1999. So your house is built before 1999. So it's still legal, but it's non-conforming as of today. Because today the laws changed, but you're still allowed to have it because you grandfathered the rule from before. Okay? So non-conforming use can apply in certain different ways. So it says some cottages fall under the status due to their age. The acquisition of shore road allowance may disrupt the non-conforming use status, invoke current zoning requirements such as minimum setbacks. So that's the same thing. Because a cottage was built in like 1940 and it's closer to the shore than it's supposed to be, it can still be non-conforming use and it's still going to go on having it because it was built way before the law changed.
Okay.
Right? So it's the same idea with the basement apartment. You had it legal before a certain year, but even though you're selling your house in 2014, but you built the basement in 1999 when it was legal, it's still non-conforming use, but you're still allowed to use it.
Okay.
Right? Cost of individual applications, these are substantial depending upon the property. Cost of survey can be expensive, like I was saying. You could be spending quite a bit of money to fight over the property boundary line or whatever the case is. All depends on the situation. Diminished frontage acquired, that's where it's it's basically from where you are looking at less than the existing measurement due to the shore road allowance. So the frontage you purchase may actually be less because there's a shore road allowance again coming into effect. So that's reducing your frontage according to what you purchased originally. Okay.
Okay.
And then the fish habitat considerations is Ministry of Natural Resources is authorized to protect fish.
Mm-hmm.
Just so you know. Okay, so that completes this chapter. I'm going to end this video now.